The Supreme Court chamber fell into a breathless hush as Justice Amy Coney Barrett's gavel struck the bench with a sharp crack. Her voice sliced through the tension, cold and clear. "Ms. Leavitt," Barrett began, eyes fixed on the young woman before her. "This court finds your repeated statements regarding our recent decision deeply troubling. You now stand perilously close to contempt." At just 28 years old, White House Press Secretary Karoline Leavitt stood alone at the podium, facing the full bench of the Supreme Court. She was the youngest person in U.S. history to face possible contempt charges from the nation's highest judicial body. Barrett's tone remained calm, but unyielding. "You have 7 days to issue a full retraction and formal apology," she continued, "or this court will be left with no alternative but to refer the matter for criminal prosecution." A collective gasp rippled through the gallery. Reporters scrambled to capture every word, fingers flying across phones. But Leavitt showed no sign of fear. Instead, she calmly opened a leather-bound portfolio. "Justice Barrett," she replied, her voice steady, deliberate, "I've prepared a 15-page legal analysis explaining why my statements are not only protected, but constitutionally sound." What followed stunned the court, the media, and a nation already on edge. Before we break down this historic legal standoff, don't forget to subscribe and share your thoughts below. Where should the line be drawn between free speech and respect for judicial authority? Appointed to the bench in 2020, Justice Amy Coney Barrett had become one of the most powerful and disciplined voices on the conservative-leaning court. Known for her sharp legal mind and methodical reasoning, Barrett was respected, even by those who disagreed with her rulings. At 52, she had carved out a space as both scholar and sentinel of constitutional interpretation. On the opposite end stood Karoline Leavitt, sharp, young, and unapologetically bold. Just 6 months into her role as White House Press Secretary, she had made headlines for her punchy press briefings and fierce defense of the administration. Unknown to many, Leavitt had quietly completed a law degree while working in earlier government roles, adding legal substance to her communication skills. Their collision was set in motion 3 weeks earlier. In a narrow 5-4 decision in Fairfield, First Department of Education, the Supreme Court had limited federal oversight of state education policy, a ruling that critics called a retreat from civil rights-era protections. During a subsequent White House briefing, Leavitt didn't mince words. "This ruling reflects a fundamental misreading of precedent and legislative intent. The majority opinion ignores 70 years of settled jurisprudence and replaces constitutional principle with ideological preference." The backlash was immediate. Legal pundits debated whether Leavitt's remarks were sharp criticism or outright contempt. Conservative commentators demanded consequences. Progressive voices hailed her courage. But now, the consequences were real. If the court found her in contempt, she faced not only potential criminal charges, but the likely derailment of her rapidly rising career. For the court, especially Barrett, the confrontation was more than a legal matter. It was a battle over the boundaries of respect, power, and independence. For the White House, it was about preserving the right to critique judicial rulings without retribution. Leavitt's summons before the full bench made headlines around the world. Constitutional scholars scoured history for parallels and found none. The New York Times called it a constitutional crisis without modern precedent. The Wall Street Journal labeled it a collision between judicial power and executive voice. That morning, Leavitt stood in the chamber under the weight of immense political, legal, and cultural pressure. Her legal team had urged a quick apology. The White House counsel had drafted a statement for her. Even the president had suggested a softer tone. But Leavitt had other plans. After 3 nights of relentless research into past contempt cases, freedom of speech doctrines, and interbranch precedent, she believed she had the legal ground to fight. What she found had convinced her to reject compromise. Now, with the gavel's echo fading and Barrett's ultimatum delivered, the stage was set for a showdown that could rewrite the rules between 2 of the most powerful branches of American government. And as Leavitt stood her ground, the nation watched, holding its breath. It was a critical juncture. The next moments would determine whether Karoline Leavitt would retreat with the apology everyone expected, or take the unthinkable step of challenging a Supreme Court justice on the interpretation of constitutional law. Most viewed such a move as professional suicide. Justice Barrett's expression flickered, brief surprise as Leavitt opened her portfolio, clearly not to read a statement of regret. Several justices exchanged glances. Chief Justice Roberts leaned in, eyebrows raised, visibly intrigued. "Ms. Leavitt," Barrett said, her voice edged with warning. "This proceeding is not a debate. The court's position on your remarks is already established." Leavitt gave a respectful nod. "I understand, Justice Barrett. However, before this court proceeds with its contemplated action, I believe it is my duty to articulate the legal framework under which any contempt finding would be evaluated." Barrett's gaze narrowed. "Proceed, but be advised. Your response may influence the court's final determination." The warning hung heavy, but Leavitt remained composed. She referenced her documents with calm precision. "Thank you, Your Honor. I'd like to begin with the legal standard for contempt as defined in Bridges v. California," she said, her tone measured. The mention of the landmark 1941 ruling caught Justice Sotomayor's attention. She looked up sharply. "In Bridges," Leavitt continued, "this court held that even severe criticism of judicial decisions is protected under the First Amendment, unless such criticism poses a clear and present danger to the administration of justice. My statements, while direct, posed no such threat." Justice Alito broke in. "Ms. Leavitt, you stated this court ignored 70 years of precedent. That crosses a line from critique to impugning the integrity of this institution." Leavitt turned to address him directly. "Justice Alito, in New York Times v. Sullivan, this court ruled that debate on public issues must be uninhibited, robust, and wide open, and may include, quote, vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. That explicitly includes judges." The chamber remained silent as Leavitt moved deliberately through her argument, citing case after case. In Craig v. Harney, this court ruled that what transpires in the courtroom is public property. It affirmed that judges are expected to withstand a hardy climate of public scrutiny. Barrett's expression held steady, firm but attentive. "Ms. Leavitt," she said, "those precedents concern the rights of private citizens and the press. You, however, were speaking as a government official in an official capacity. That distinction may prove consequential." It was the opening Leavitt had anticipated. "Justice Barrett, I respectfully refer the court to Garrison v. Louisiana," she said, turning a page in her binder. "In that case, a district attorney's public criticism of judges was deemed protected speech. The court wrote, and I quote, "Speech concerning public affairs is more than self-expression. It is the essence of self-government." The room seemed to tighten. This wasn't defiance. It was doctrine. Reporters had stopped typing. Eyes were locked on Leavitt. Justice Kagan leaned toward her microphone. "Ms. Leavitt, your command of precedent is noted. But there is a line between criticizing a ruling and alleging that the court intentionally misinterpreted the law. The latter implies bad faith." Leavitt nodded. "Justice Kagan, I appreciate the nuance, but I would remind the court of Wood v. Georgia. In that case, a sheriff accused judges of political bias directly. His remarks were protected. The court emphasized that the political role of elected officials makes it imperative they speak freely, even when their views concern the judiciary. The tension in the chamber now felt electric. What began as a disciplinary hearing had transformed into a moment of constitutional reckoning. On matters of pressing public concern, Justice Barrett's expression shifted, subtly but unmistakably, from stern disapproval to reluctant engagement with Leavitt's argument. "Ms. Leavitt," she said, "you've cited several cases. Yet none addressed direct statements from White House officials regarding Supreme Court rulings." "That's correct, Justice Barrett," Leavitt acknowledged. "But I would submit that the absence of precedent limiting such speech should weigh in favor of its protection, not its restriction. As this court affirmed in Texas v. Johnson, We hold a profound national commitment to the principle that public debate must remain uninhibited, robust, and wide open. The tone of the chamber had transformed. What had begun as a reprimand was now a rigorous legal exchange. Leavitt pressed forward, citing precedent after precedent with clarity and precision. Then, unexpectedly, Justice Thomas spoke, a rare occurrence. "Ms. Leavitt," he said, his voice low and deliberate. "While your legal reasoning is thorough, it doesn't address a deeper issue, respect for institutions. Your comments risk undermining public confidence in this court." Leavitt turned to him with measured calm. "Justice Thomas, I understand and deeply respect your concern, but in Landmark Communications versus Virginia, this court held that potential injury to institutional reputation is not sufficient grounds to suppress otherwise protected speech." The majority opinion went further, stating, "The law gives no shelter to the judge who seeks to hide behind the robe to avoid public criticism." The quote hung in the air, its precision cutting through the tension. Several justices visibly shifted in their seats. What had been expected to be a short disciplinary proceeding had turned into a full-scale constitutional reckoning. Far from being chastened, Leavitt had commandeered the moment, and she showed no sign of yielding. Justice Barrett leaned forward, her posture no longer that of a reprimanding authority, but of a jurist wrestling with argument. "Ms. Leavitt," she said carefully, "are you suggesting there are no limits on how administration officials may characterize this court's decisions?" "Not at all, Your Honor," Leavitt replied. "There are clear boundaries. Direct incitement to ignore or defy a court order, as in Bridges, would undoubtedly fall outside protected speech. But strong criticism of legal reasoning, even sharp-pointed critique, remains squarely within First Amendment protection under this court's own precedents." With each citation, each carefully chosen phrase, the atmosphere in the chamber deepened into something no one had anticipated, a showcase of constitutional scholarship, led not by a justice but by the youngest person in the room. The justices, many of whom had expected a simple apology, now listened with focused attention. Leavitt turned to the next page of her materials, her voice firm and steady, now carrying a tone of confident authority. "If I may," she said, "I'd like to place my remarks in historical context." Justice Barrett, who had planned to end the hearing with a simple ultimatum, found herself nodding silently. The momentum had shifted. "Throughout our nation's history," Leavitt continued, "presidents and members of the executive have issued criticisms of this court far more direct than mine, without contempt proceedings." She paused, then spoke, with deliberate clarity. "President Jefferson dismissed Marbury versus Madison as twistifications of the Constitution. President Jackson famously responded to a Supreme Court decision by saying, 'John Marshall has made his decision, now let him enforce it.' President Lincoln, in his inaugural address, openly rejected the reasoning of Dred Scott." A hush fell over the room as those examples landed. Leavitt continued, moving into the modern era. In 2010, President Obama criticized Citizens United during his State of the Union, with 6 justices seated before him. In 2017, President Trump referred to a federal judge as a so-called judge after an unfavorable ruling. Neither faced contempt. She paused again, letting the room absorb the full weight of what had just been said. What had started as a disciplinary proceeding had evolved into a moment of legal and historical consequence, challenging not just Leavitt's right to speak, but the boundaries of governmental power in American democracy. Justice Sotomayor interjected, her tone pointed. "Those were statements made by presidents, Ms. Leavitt. Your position is not the same." Leavitt responded without hesitation. "Respectfully, Justice Sotomayor, the legal standard for contempt does not carve out separate categories for presidents versus other executive officials. In fact, press secretaries have historically criticized Supreme Court rulings without facing sanctions. Ron Ziegler under Nixon, James Brady under Reagan, D.D. Myers under Clinton, and Kayleigh McEnany under Trump all issued public statements directly challenging the court's decisions." She paused, then shifted smoothly into the most compelling part of her argument. a direct analysis of her own remarks against the controlling legal standard. "If I may, I'd like to draw the court's attention to the exact language I used," she said, producing a transcript of her press briefing. "I stated that the ruling represents a fundamental misreading of precedent and legislative intent. That is a legal assessment, not a personal attack," she continued, steady and deliberate. "I said the majority opinion ignores 70 years of established jurisprudence. That's a critique of legal methodology, not an assault on judicial integrity." Then, locking eyes with Justice Barrett, she added, "Under Bridges v. California, contempt requires a clear and present danger to the administration of justice. My statements posed no such danger. They questioned reasoning, not legitimacy." Barrett, who had entered the chamber fully confident in the outcome, now faced an unexpected reality. The press secretary she had expected to censure was presenting a calm, precise, and deeply informed constitutional defense grounded in the court's own precedents. "Ms. Leavitt," Barrett said finally, "your knowledge of precedent is impressive, but your role as White House press secretary carries the implied authority of the executive. That weight matters." It was exactly the moment Leavitt had anticipated. "That's a critical distinction, Justice Barrett," she replied, turning to the final section of her brief, "and one this court addressed in Garcetti v. Caballos. There, the court held that when public employees speak pursuant to official duties, their speech may receive diminished First Amendment protection. However, Garcetti carefully distinguishes internal workplace speech from public commentary on matters of public concern." Her command of case law was astonishing. She cited page numbers, direct quotations, and concurring opinions. Several clerks could be seen flipping through books and tapping keyboards, only to confirm the accuracy of every citation. "More importantly," she went on, "in Lane Veers Franks, this court clarified that public employees who speak on matters of public concern retain robust First Amendment protection. A Supreme Court ruling with sweeping implications for national education policy is undeniably such a matter. And as press secretary, it is my duty to communicate the administration's views on precisely those issues." The chamber was utterly still. What had begun as a disciplinary hearing had become something altogether different, a rigorous, methodical demonstration of constitutional doctrine. Justice Barrett, recognizing how far the proceeding had veered from its intended path, tried to steer it back. "Ms. Leavitt," she said, "this court retains the authority to defend its institutional integrity. Regardless of legal technicalities, your statements reflected clear disrespect." Leavitt nodded respectfully, then delivered the final blow, quietly, firmly, and unshakably. "Justice Barrett, I have the utmost respect for this court. It is precisely because of that respect that I believe robust debate about its decisions is not only permissible, but necessary." She paused. "Indeed," she said, "as you yourself wrote in your 2019 article in the Notre Dame Law Review, respectful disagreement is not disrespect. The ability to criticize judicial reasoning is essential to the health of our constitutional democracy." The silence was absolute. Barrett's own words, quoted verbatim and in perfect context, now hung in the air. Several justices looked toward her, their expressions unreadable. After a moment that felt suspended in time, Barrett finally spoke. "Ms. Leavitt," she said, her tone carefully neutral, "the court appreciates the thoroughness of your presentation. We will need time to consider the points you've raised." She glanced toward Chief Justice Roberts, who gave a barely perceptible nod before addressing the chamber. "This court will take the matter under advisement." "The court will take your arguments under advisement," Chief Justice Roberts said calmly. "We will issue our determination within 48 hours. This proceeding is adjourned." As the justices rose, the gallery erupted into hushed murmurs. Legal observers who had expected a routine disciplinary session had instead witnessed something extraordinary. Karoline Leavitt, the White House press secretary, had just delivered a masterclass in constitutional law, citing the court's own precedents. In her defense, there was no cheering, no fanfare, but the significance was undeniable. What was intended as a public reprimand had transformed into a serious constitutional debate, and Leavitt had held her ground, poised, brilliant, and unshaken. As she gathered her materials and prepared to face the press outside, both allies and critics knew they had witnessed the emergence of a formidable legal mind, one that had gone toe-to-toe with the highest court in the land. The moment Leavitt stepped outside the Supreme Court building, a wall of cameras and microphones awaited. Flashes lit up the steps as reporters shouted questions from every direction, but Leavitt, composed as ever, offered only a brief statement. "I've presented my position to the court. Out of respect for their deliberative process, I'll reserve further comment until their decision is released." The restraint in her words only deepened the impact of what had unfolded inside. Within minutes, legal experts across the nation began dissecting the moment. At Georgetown Law, Professor Lawrence Tribe addressed a stunned room of students. "What we witnessed today was unprecedented," he said. A press secretary turned a contempt hearing into a substantive First Amendment seminar, armed with case law, page citations, and remarkable precision. On CNN, legal analyst Jeffrey Toobin looked almost breathless. "In all my years covering the court, I've never seen anything like this." Leavitt didn't just defend herself, she gave a lecture to the justices. Even conservative commentators offered begrudging praise. Former federal judge Michael League remarked, "Though I disagree with her interpretation, her legal argument was masterfully constructed. The court now faces serious constitutional questions it cannot ignore." As analysis flooded news networks and social media, a new revelation emerged, one that had been conspicuously absent from Leavitt's public resume. The Washington Post ran a feature within hours. "Behind the Podium, Karoline Leavitt's Hidden Legal Background." The article detailed how Leavitt had quietly completed a rigorous evening law program while working full-time on Capitol Hill, graduating with a 3.9 GPA. A former professor, speaking anonymously, described her as one of the most gifted constitutional thinkers I've taught, someone who could recite precedents from memory and apply them with striking originality. Inside the White House, the mood shifted from concern to astonishment. Advisors who had urged her to apologize were now watching live TV as experts praised her performance. "We had a draft apology ready," a senior staffer whispered. "None of us knew she'd spent the weekend building a constitutional defense." Later that night, the president called her personally. According to sources, his words were simple. "You made history today. Whatever happens next, I'm proud to have you speaking for this administration." Meanwhile, inside the Supreme Court, an emergency conference convened, a rarity in itself. The 9 justices, unsettled by the force of Leavitt's argument, met behind closed doors. Justice Barrett reportedly opened the discussion. "We summoned Ms. Leavitt expecting a simple contempt review. What we received was a sophisticated First Amendment defense, anchored in our own case law. We must tread carefully." Even those who had disagreed with Leavitt's original statement acknowledged the strength of her legal analysis. Justice Kagan was said to have remarked, "Whatever our decision, we've all gained new respect for her constitutional command." Law schools rushed to respond. Harvard announced a symposium, "Executive Speech and Judicial Criticism, Constitutional Boundaries After Leavitt." Stanford scheduled a panel of former clerks. Yale Law's online forum published a rapid response titled, "Contempt and Criticism, The Court's Dilemma Post-Leavitt." The article outlined the court's stark choice: either withdraw the contempt threat and appear to affirm Leavitt's arguments, or pursue contempt and risk violating the very First Amendment protections the court had long upheld. On social media, hashtags like "Our Legal Genius" and "Our Supreme Showdown" trended for days. TikTok videos breaking down Leavitt's composure and rhetorical strategy amassed millions of views. Across party lines, young women cited her as a new role model, one who had stood in a marble courtroom and made the Constitution her shield. Exactly. 48 hours later, the Supreme Court released its decision. In an extraordinary 9-0 ruling, the court declined to pursue contempt. The brief opinion acknowledged the substantial First Amendment considerations raised, and reaffirmed the vital role of robust public discourse regarding judicial decisions. Justice Barrett issued a separate concurring opinion, one that would be studied for decades. While this court retains authority to safeguard the dignity of its proceedings, it must also respect the constitutional boundaries of that authority. Ms. Leavitt's argument reminded us that criticism of legal reasoning, even pointed criticism, is not only protected, it is essential. A democracy that cannot withstand critique of its courts is no democracy at all. For Karoline Leavitt, the decision was more than personal vindication, it was a constitutional milestone. At her next White House briefing, a reporter asked about her stunning legal performance. Leavitt answered simply, "I believe deeply in the First Amendment, and in the Supreme Court's role in our democracy. I'm grateful that the justices engaged so thoughtfully with the questions I raised." Indeed, the weeks that followed, law school applications surged, particularly from young women inspired by her example. Professors noted a spike in interest in First Amendment and separation of powers jurisprudence. Perhaps most notably, the dynamic between press secretaries and the court began to shift. Future administrations became more careful, focusing on legal critiques, not personal attacks. The court, in turn, became more measured in its responses to executive speech. 6 months later, Justice Barrett invited Leavitt to speak at Notre Dame Law School. The event sold out in minutes. In her introduction, Barrett reflected on the unlikely arc that had brought them together. Ms. Leavitt reminded us that rigorous debate strengthens the judiciary, it doesn't undermine it. Her legal brilliance surprised many. But in America, brilliance isn't confined to judges or professors. It can emerge from any podium, even the one at the White House. As Karoline Leavitt took the stage to thunderous applause, the journey from potential contempt defendant to respected constitutional voice came full circle. What began as an attempt to silence criticism had instead set a new precedent, one that reaffirmed the power, necessity, and constitutional protection of political speech.